June 7th, 2022. Please silence all electronic devices and mute your microphone. We'll now proceed with public hearings, starting with ordinance P80.
Madam Chairman and members of the board, we have approved the publication of the hearing of this matter at this time in the May 22nd edition of the Tampa Bay Times.
Okay. Good afternoon.
Good afternoon, Madam Chair, Commissioners. Denise Hernandez, Planning and Development. This item, which is PDD 220397, this is the first reading on the item. I will read the title. It's an ordinance by the Board of County Commissioners amending the Pasco County Land Development Code Ordinance Number 89-21 as amended, providing for amendments to Section 406.1 signs, Section 601 traditional neighborhood development, Section 1200 nonconformities, creating Section 1203.4 nonconforming signs, amending Appendix A definitions, providing for additional amendments as necessary for internal consistency, providing for applicability, repeal, or severability, inclusion into land development code, modification, and an effective date. So by way of history, see if I can bring the PowerPoint up. So these amendments that are before you, basically, we've been working on these since probably 2017 or so. So there are several parts to these amendments. The first being is that we needed to be compliant with the Reed versus Town of Gilbert Supreme Court decision of 2015. So basically, Reed versus Town of Gilbert, the United States Supreme Court addressed the constitutionality of a local sign ordinance that had different criteria for different types of temporary non-commercial signs. As a result of that decision, it's appropriate and necessary to modify and update certain sign regulations in order to respond to the parameters outlining permissible government regulation of signage. Additionally, in 2019, on April 2nd, there was a workshop to the board regarding digital signage, and the Board of County Commissioners directed county staff to move forward with modifications to 406.1 to allow digital signs for office, commercial, and industrial districts. And then those types of entitled properties within the MPUD district. Additionally, just recently, we added that there could be digital signage for homeowner associations and condo associations that are established per Florida Statutes 720 and 718, respectively. In addition, the 406.1 signs was restructured for ease of use. We clarified terminology throughout the section. These, we moved nonconforming signs to 406.1, from 406.1 to 1203.4 nonconforming signs. We added prohibited materials to the prohibited sign section. We added maintenance standards for temporary signs. We added computation of sign shape and area. We actually took that from 60110 and moved it into 406.1 as well. We also added non-substantial and substantial modifications to unified sign plans, which were not present in 406.1. So the subject proposed amendments were presented to and discussed with the LDC interested parties and horizontal roundtable group on April 18th, 2022. In addition, prior to that time, we did send out the sign code updates to the horizontal roundtable and interested parties folks, and the changes have been on our website since that time. And on June 2nd, 2022, the local planning agency unanimously found the proposed amendment consistent with a comprehensive plan and recommended approval to the board. Today is just your first reading, so we're asking you to accept public comment. There's no action required by the Board of County Commissioners, as this is the first of the two hearings, and the adoption hearing is set for June 21st, 2022. I do want to say that we have met individually with commissioners, and there have been some comments that have been made, and we will be addressing those prior to the adoption. So there's a few tweaks that we still need to do. So I am here for any questions you may have.
I have some questions, but I'll let my fellow commissioners go first. You guys have any questions? Okay, we talked about some cleanups. And
Yes.
So where are we on
so
those?
those will be addressed. So the cleanups that we talked about, to put those into the record, are the section about the materials that can be used for signs. There was a concern that by stating that they're unfinished materials, that would potentially disallow artistic metals. So we're going to be taking that into consideration. There was also a comment about the temporary signs maintenance standards and that they have to be removed within 24 hours notice by the county and safely stored when the government authority states that weather conditions require storage of loose items. You wanted to button that up a little bit. I will be discussing that with Christy Sims. And then the last item was regarding the homeowners association, condo associations, and community development districts, the signage, where they're not for them not to be visible from collector and arterial roads.
Yeah, they're.
So those are things we're going to be working on.
At their community buildings, not at 54 and Starkey or whatever. One more thing that I want to discuss, and maybe you can do a little research. A temporary sign can be with a, what's the flapping one? The feather banner, is that what we call
Feather
those?
banner, yeah.
We don't have any restrictions on the width. And while I see that the industry standard may be 7.5 feet or 8 feet by 2 or 2.5, to have an 8 foot by 4 foot flapping feather banner is
Yeah.
not okay.
As discussed, that section just basically discusses all kinds of temporary signs. So a temporary sign cannot be any more than 4 feet wide by 8 feet.
Yeah, except that.
In height. You can't, like, it doesn't specifically say a feather banner can't be that. It's just a temporary sign altogether cannot be more than 4 by 8.
And I would like to add that a feather banner cannot be any wider than 2.5 feet. Because a 4 foot flapping piece of fabric can hurt somebody. And while I don't think you can buy one,
I don't think
someone
you can
could
buy
make
one.
one.
Yeah.
And that's a real hazard at 4 feet. So, what kind of materials do we require in the way that they put up their temporary signs?
So, so there's different types of materials. Are you confusing the temporary signs with permanent signs?
No?
Okay.
If you
Because the
wanna
temporary
put a tem-
signs, I mean, a banner can be placed on an actual, fence. A banner can be placed on posts, so it could be hung by posts. And then a feather banner has that actual wire component that is part of the structure of the feather banner.
Okay, so the posts, you're talking about like 2 pieces of wood?
Yes.
And what are the restrictions on where that wood can be on their property?
So the setbacks haven't changed. So the setbacks for the temporary signs, let me go into that section.
I mean, cannot be in public right away?
No, they can never be in the public right of way. That's completely
Although they
prohibited.
do it all the time on 54.
Right, but it's prohibited.
In Lutz.
Completely prohibited. So 5 feet from the right-of-way line and 20 feet from the intersection of any rights-of-way. So it's in
Okay.
section 406.1, point B, point 2.
And they can be two-sided or just one side?
They can be, the code doesn't say that, so we can clarify that. But it's usually just one-sided.
Right.
Because
Just-
two-sided means they're putting 2 signs together.
So just little cleanups.
Sure.
Okay, any other? See, I personally
Madam-
just want to get rid of those, but I know I may be the
Yeah.
only one. Yes.
Madam Chair, I would like to hear the views of, are you allowed to use a blow-up inflatable sign such as an icy if they're having like a free icy day or a grand opening? Then,
Those are prohibited.
Yes.
Those are prohibited signs.
even if it's a temporary one
They're
day
prohibited.
to bring in advertising?
They're
Trying
prohibited.
to prohibit. You know, a lot of communities don't allow temporary signs at all. We're kind of out there still allowing these in this day and age. So.
You
just
said
saying.
communities, so is this only
A lot of
residential? or is-
counties, a lot of, we're a county that acts like a city,
Mm-hmm.
because we don't have any big cities. So the trend is to not allow temporary signs at all.
I'll give you an example. The 7-Eleven will open up somewhere. We all know it's a brand-new 7-Eleven,
Yeah.
Right.
but they don't need 20 signs flying in the air
Right.
to show that. They can have one, I believe, and that's good enough.
Yeah, everyone's allowed to have one temporary sign.
They can have one temporary sign, and then The direction of the board back in 2019 is that if the property has digital signage, then they can't have additional temporary signage, because digital signage allows you so much more messaging over just a regular monument sign.
Well, I just bring up the inflatable because I saw one the other day.
Yeah.
And if it's National Free Slushy Day or something, if they're advertising something for one day, they can't even have that.
No, it's a prohibited sign.
Which I am fine with. Okay, I don't think there's any action required.
You need to have a public hearing.
Madam Chair?
Nope. Okay, we'll take public
Madam
comment.
Chair?
After Commissioner Marianas.
Thank you. Denise, I'm very appreciative to meet with you and Elizabeth about this, that you're bringing it forward. It's been a long time coming, a lot of things you have to take care of. I'm very happy with the response I got. One of the places that was concerned was Summer Tree. They were thrilled with what was going on. I don't know if she got a hold of the people at Stockyard. I didn't hear anything from them.
So I will say that, and I should have started by saying this, that my good friend and colleague, Elizabeth Blair, who would typically tag team on this with me,
Right.
she's under the weather.
Right.
So I believe she did put in a call or an email, she just hasn't heard back from them.
Okay. And there was one of the group that was...
And then
that had
she
some-
reached out to that attorney that you asked her to reach out to, and she's heard back from that
And
person.
she's good with that one too, so
Yeah,
that was good.
yeah.
The last one was just, was some building signs that was going on with a new complex. It was kind of like doing some work and they were having some
Yeah,
trouble,
but that's
so-
something that's handled under the current
Different
code.
thing,
It's
okay.
not, it
Well,
won't be
great.
affected by this.
Great job with this.
Yeah.
I think it's going to be great, even for like our own libraries. Where now, instead of having to go change all the things back and forth, now they can just have a sign that they can change. It's going to be some great efficiencies, and I think it'll look better as well.
You know, I didn't ask you, but we did control the lumens and foot candles and all that
Yes.
stuff.
Oh, that's all in there. Yeah.
Okay,
Yeah, Elizabeth was a big champion for NITS.
okay.
Yeah.
All right, does anyone in the public wish to speak to this? Anyone online wish to speak to this?
We have no one online.
And you met with stakeholders and all groups and,
Yeah, so we, again, sat through, we went line by line in every single section with the horizontal roundtable and interested parties, and we've had this on our website with any questions or concerns, reach out to Denise Hernandez. Haven't heard back, and I do want to say that this doesn't happen in a vacuum. We've talked to code enforcement, building construction services, several folks in the county attorney's office, not just Elizabeth, Christy, Nikki, David. I mean, it takes a village to do something like this. So I'm very grateful for my village and my tribe.
the other thing that didn't come in that I wished for was a sunsetting of the old ugly signs. And I would have liked to, I mean, signs only have a lifetime. They don't last forever. And so I would have liked to have been able to sunset the old ones that, in my opinion, when you have a new McDonald's with the new monument sign that looks so nice, and then you have the Burger King with the sign from 40 years ago that's 3 times, 4 times bigger, it's not an even fair playing field, and I think we should be getting everyone to the same level playing field, and even if we have to give an economic incentive.
I think with the creation of 1203.4, you're going to see that there's a lot of that stuff that's going to come down, because you'll have to bring the property into conformity in so many different instances. So I think
Well,
you'll see them.
I see businesses change, like we had, I don't even know what the business was, now it sells marijuana, but they didn't have to change the sign, and we kind of missed it with code enforcement, but they just put a new face on it, now it's whatever that marijuana company is.
We might see some real good benefit with this, though, because I think this gives a business a good chance to be able to put a product out there, or something that's going on, and make it look better
I
doing it,
mean,
so
they may switch to the digital?
when they
is that what
switch to
you're
digital, yeah. So I think we're gonna see a lot of people want to do this, and I think it's gonna improve the old signs to go
I
go
hope
this
so.
way.
I hope so.
Listen.
Okay, thank you. P81?
All right, so P81 is, it was actually scheduled today for adoption by roll call vote, but we've received a request for continuance. I'm sorry, I guess you need the,
Is Barbara online?
We do have proof of
Publication.
publication of, in February 16th edition of the Tampa Bay Times. for this matter at this time.
So P81 is PDD 220029. It was scheduled for adoption. This is for North Ridge for a comp plan amendment, changing the future land use from Res 1 to PD. The applicant has requested a continuance to the July 12th, 2022 Board of County Commissioners meeting at 1:30 in Dade City.
Move to continue, time certain.
I think you may need to call for public comment.
I will see if anyone's here to speak on P81. Is there anyone online to speak to P81?
We have no one signed up nor online.
Okay, I have a motion and I have a second to
I'd
continue. All in favor?
Aye.
Opposed? Passes, thank you. P82?
We have proof of publication in the April 6th edition of the Tampa Bay Times for the hearing of this matter.
All right, so P82 this is the adoption on this item, so we're asking you to accept public comment, adopt by roll call vote. This went to the local planning agency on April 21st, 2022, who found it consistent with the comprehensive plan and recommended approval to the board, and it went to the board for first reading on May 17th, 22. It's an ordinance by the Pasco County Board of County Commissioners amending the Pasco County Land Development Code, Chapter 500 zoning, Section 509 ER Estate Residential District, Section 510 ER2 Estate Residential District, Section 512 R1MH Single Family Mobile Home District, Section 514 R1 Rural Density Residential District, Section 515 R2 Rural Density Low Density Residential District, Section 516 R3 Medium Density Residential District, Section 517 R4 High Density Residential District, and other sections as necessary for internal consistency, providing for applicability, repealer for providing for severability, inclusion into Land Development Code, and an effective date. So just to let you know, this is the residential building height increase from 35 to 45 feet. So today is the adoption. We ask that you accept public comment and adopt by roll call vote.
I know we're all in support of this. Does anyone here want to speak to this issue? Is anyone online to speak to this issue? I'll take a motion.
No, ma'am.
Move approval.
Second.
Is this a roll call?
Yes, it is.
Roll call?
District 1, Commissioner Oakley.
Aye.
District 2, Commissioner Moore is absent. District 4, Commissioner Fitzpatrick.
Aye.
District 5, Commissioner Mariano.
Aye.
District 3, Chairman Starkey.
Aye.
Thank you.
P83.
We have proof of publication of this matter in the April P82.
Good afternoon, Madam Chair, members of the board. Justin Ressler, Solid Waste Director. P83 is an ordinance amending Chapter 90, Article 2 of the Pasco County Code of Ordinances, Solid Waste Collection and Disposal, Division 2, Sections 90-47, 90-48, 90-64, providing for repealer, providing for severability, providing for applicability, providing for inclusion in code, and providing for an effective date. This is the second reading. Next slide, please. This is the ordinance amendment which removes the residential waste collection ceiling and indexes it with the CPI for garbage and trash collection. Over the past several years, we've seen market increases in both fuel and labor costs, and so we brought this for the board to consider. Ultimately, it is the haulers who set the waste collection pricing. What we are doing here today is we're presenting an ordinance that would increase the maximum allowable rate they'd be able to charge. This would not have any impact on existing HOA hauler contracts. With that, the department recommends that you accept public comment, adopt the proposed ordinance by roll call vote, authorize the chairman to execute the ordinance amendment, and direct board records to retain the original and final electronic copy of the ordinance with the Department of State within 10 days of adoption.
Just for the record, this is not the second public hearing. This is the first public hearing on this item, but it only needs one.
Oh, I thought we heard this already.
You heard introduction.
Okay.
And for clarification, the proof of publication was the May 18th edition of the Tampa Bay Times.
Okay, board members, any questions?
Madam Chair?
Yes.
I think as we talked about it, there has been some major increases that they're struggling with, and the one thing we want to make sure is the trash does get picked up. I will make note for anybody out there that has an HOA, as Justin mentioned. My own HOA, Beacon Woods, I actually reached out to them this morning to say, this increase, if it does go through, is going to affect everybody here. You may want to look at getting your HOA to contract individually with a hauler. And one of the things that prompted that was all of a sudden we have like more than one hauler in the neighborhood. So if you want to cut down the trucks coming in,
Yeah.
as well as that goes, maybe it's a good move to make that move.
And it's so much better for your roads and for your, you don't have the sound, you know, every day of the week. So that's a good thing. Okay, does anyone here wish to speak to this item? Is anyone online?
No, ma'am.
Roll call?
Move approval. Did we have a
Second.
vote? I didn't
Oh,
hear.
sorry.
Motion.
Motion?
Yeah, motion?
Second? Roll call?
District 1, Commissioner Oakley.
Aye.
District 2, Commissioner Moore is absent. District 4, Commissioner Fitzpatrick.
Aye.
District 5, Commissioner Mariano.
Aye.
And District 3, Chairman Starkey.
Aye. We will now proceed with public hearings. Will the county attorney please review the procedures for rezoning?
Be happy to. There are 2 rezoning agendas, regular and consent. Staff will present each application to the Board of County Commissioners. If staff or Planning Commission has recommended approval and there is no opposition, the application will be considered by the board without further presentation. If staff or Planning Commission has recommended denial, or if there is opposition to the application, the applicant will be given 5 minutes for a presentation. The opposition will be given 3 minutes for each individual or 5 minutes for a group representative, and the applicant will be given 3 minutes for rebuttal. Any individual disagreeing with staff or Planning Commission recommendation, or anyone wishing to object to any condition of the rezoning, may at this time request that the petition be pulled from the consent agenda, in which case that application will be heard under the regular agenda later on during the meeting. Otherwise, all rezoning applications on the consent agenda will be approved by a single motion and vote. If you wish to speak to any petition, please give your name and address and whether or not you've been sworn for the record. These are quasi-judicial public hearings. The law in Florida is that mere public support or opposition of an application is insufficient for this board to take action. Please limit your comments to those criteria found within the board's land development code.
All right, those who are in person who have pre-registered to speak to any of the items on the public hearing agenda will be sworn in now by the clerk.
Please rise. Those of you who are wishing to or intending to present information to the board, please raise your right hand. Do you and each of you swear or affirm that the testimony you will give is the truth, so help you God? Thank you. Please, when you step forward, if you will confirm for the record your name, your address, and spelling your last name, and confirm if you have been sworn. Thank you. We have proof of publication of the hearing of this matter in the April 20th edition of the Tampa Bay Times, item P84.
All right, P84.
PDD 227565, this is Faircloth MPUD for rezoning request from AC to MPUD. This is a request, the applicant has requested a continuance to the June 21st, 2022 Board of County Commissioners meeting at 1:30 in Newport Richey.
All right, is there anyone
No,
here?
These were advertised continuances. You can just take
Oh,
action.
okay. All right, do we take a motion? or
Motion
was
to
this on
continue.
consent? Okay, second? Is there a second?
Second.
All those in favor? Aye. Opposed? P84 is continued.
Did the clerk's office
P85?
get who made the motion? This first?
I made the motion.
Okay.
She made the second. P85.
P85 is proof of publication in the Tampa Bay Times, April 20th, 2022.
P85 is PDD 227574, Gail Collier MPUD Master Plan Unit Development. This was also advertised as a continuance, but the actual new request is to continue to a date uncertain. It was continued to a date uncertain by the local planning agency on June 2nd, 22.
Motion to continue.
Second?
All in favor? Aye.
Aye.
P86.
P86 does have proof of publication on the April 20th, 2022 edition of the Tampa Bay Times.
PDD 227619 in the name of Bay Area Merchandising LLC is for a change in zoning from C1 Neighborhood Commercial District to R4 High Density Residential District. Comes to you with a recommendation of approval from the Planning and Development Department and the Planning Commission.
Okay, board members, any questions? Is the applicant here?
This item is on consent.
It's on consent. Does anyone here wish to speak in opposition to this item? Is there anyone online to speak in opposition?
We have no one
Pulling
online.
up the map. Okay, we'll leave it on consent. And my notes say there are 2 on consent, but I
Yep.
don't see 2 on
Yep,
consent.
87.
Next page.
And next one.
Okay, mine doesn't say. Okay. Oh, it does. I didn't highlight it.
P80
P87.
P87, we have proof of publication in the April 20th, 2022 edition of the Tampa Bay Times.
It's PDD 22CU18. This is a land excavation operating permit and conditional use amendment request for Cytex NR Holdings LLC for an operating permit and a conditional use permit for land excavation in an MPUD Master Plan Unit Development District. This comes to you with a recommendation of approval with conditions from the Planning and Development Department and the Planning Commission, and that's as contained in your agenda packet.
Okay, is there anyone here who wishes to speak in opposition to P87? Do you have anyone online?
No, ma'am.
All right, we'll leave it on the consent, and I will accept motion for the consent.
Motion. Second.
All in favor of the consent consent items, signify by saying aye. Aye. Opposed? All right, P88.
P88, we have proof of publication in the April 20th, 2022 edition of the Tampa Bay Times.
Good afternoon, Liam Devine, Planning and Development. Item P88, before we begin, I would like to request to receive and file a declaration of easement. It should have been an attachment that was not included in your original packet. I have placed a copy on each of your desks, and I have submitted it already to the clerk's office.
Motion to receive and file.
Second.
All in favor? Aye.
Item P88, PDD 22-7616 in the name of Bushnell DD LLC. It is a zoning amendment from AR Agricultural Residential District to a C2 General Commercial District. The subject site is located on the south side of County Line Road, approximately 1,000 feet west of Suncoast Parkway Extension. And this is a look at the aerial view. The surrounding future land use to the north, east, south, and west is all Res 1. The surrounding zoning to the north, south, and west is AR, and to the east is C2. The subject site consists of a mobile/manufactured home and accessory structures on approximately 3.86 acres. The applicant proposes to develop the property with a Dunkin' Donuts and other commercial uses in conformance with the C2 General Commercial District standards for development. Access to the property is from February Lane, a county-maintained local road with approximately 70 feet of right-of-way, and Simbora Drive, a privately maintained ingress-egress easement with approximately 20 feet of paved asphalt. The subject site currently has a future land use classification of common commercial. The applicant has voluntarily agreed to record a deed restriction with a minimum of type A buffer and a 6 feet in height opaque fence or wall along the south of the subject site. And then they have also agreed to maintain the easement for Simbora Drive to county standards. And this is coming with a recommendation for approval from Planning Commission and Planning and Development Department. I'm here if you have any questions.
I don't have any questions. Anyone? All right. Does the applicant want to make a presentation?
Madam Chair, Commissioners, Todd Pressman, 200 2nd Avenue South, number 400 in St. Petersburg, Florida. Appreciate your time this afternoon. This is a request which at first you've approved a future land use amendment some time ago to commercial, which was approved, which is why the rezoning is coming forward. Your staff is recommending approval, and your Planning and Zoning Board recommended unanimous approval. We are seeking AR to C2 for 3.86 acres. C2 is abutting the property on the east, and to the north across county line is a commercial future land use category. The site is just a stone's throw from the Veterans Expressway. County Commissioners, as indicated in the report, have approved similar zonings in the immediate area. Now, I have spoken on the phone with two of the nicest ladies I've run into with these kind of issues. They are the owners abutting to the south. So directly because of their concerns raised at the Planning and Zoning Board, we agreed to a condition to maintain Simbora for the area that this property is fronting, and we've also agreed to, as Liam indicated, a type A buffer with a fence, which, not speaking for them at the time, and as subsequent conversation, they appeared very comfortable with that. So with that, I'll be happy to answer any questions or answer any questions from the nice ladies that are here.
I do have a question just from our conversation this morning. Are there utilities here?
Yes.
Okay. That was my one.
Madam Chair? So you have water and sewer?
That's my understanding. I think I'll take a quick look back at the
Okay.
report, but I believe that is correct.
Okay, is there anyone here from the public who wishes to speak on this item?
We have two, Cheryl Gant.
Okay, name and address for the record, please.
And whether
My
or
name
not
is
you-
And whether you've been sworn in.
Pardon me?
Have you been sworn in?
Yes.
Okay.
My name is Cheryl Gant. I live at 18820 Simbora Drive. I have actually brought some documents and some pictures for y'all to look at.
Move to proceed and vote.
Second.
All in favor?
Aye.
I've rehearsed this, so I hope I get it 3 minutes here. I'm here with my mom, same address, Carol Simbora Gant. We're here because our road, Simbora Drive, aligns next to the property that Bushnell recently purchased. I've provided documents, pictures, deeds, and surveys. On May 5th, my mom and I went to the Planning Commission meeting. We were naive with those proceedings. We stated we didn't mind the zoning change. We just wanted a buffer from the commercial property and for Bushnell not to use our driveway. We stated that Simbora Drive is a privately owned road and that we were told by the board that the easement rights were given to the adjoining property owners when they bought the property and that Bushnell could use it for public use. The board stated it was a civil matter and to try to work it out ourselves regarding the maintenance of the road. In May of '62, my great-grandmother obtained 10 acres of land on County Line Road. My grandparents, the Simboras, bought the land. 4 generations of my family have lived on this property. In '79, my grandparents divided the 10 acres into 4 2.5-acre plots, one for them and the other 3 plots for their 3 daughters, and they made a declaration of easement. A planning board member said that my grandparents should have used a lawyer and that the easement didn't state no commercial use. It was to be used by all 4 plots. After the meeting, we located the easement document. John H. Bonner of Bonner and Hogan, PA, did prepare the document. An attorney was used. No commercial use was probably admitted because it was all zoned for residential agriculture. We sought legal advice. I was informed that the court of law looks at the intent of the declaration. To me, the intent is obvious because it was all zoned residential agriculture, meaning our family, and this is proven evident on the survey. My grandmother handwrote the family names on the 4 plots. During the planning meeting, a woman from the road department said that it was a viable road to use. Only 1/2 of the road is wide enough for 2-way traffic. The rest is a single lane. There are no dividing lane lines, no dead-end signs, and it's thinly gravelled. Even garbage trucks tear it up. There's gopher turtles that need to be relocated from the property as per SB 494. And Bushnell has over 155 foot of frontage on February Lane just from the one parcel. But there is a paved entrance over a cement drain that already exists. There's no need to pass by that entrance and use Simbora Drive. I spoke to Liam Devine last week and he informed me that Bushnell was to maintain the road per the county standards. Liam said there was supposed to be space for 8 vehicles at the order board for Duncan. Will that line back up in their parking lot or on Simbora Drive? Will I be blocked from my home? Liam said that my taxes shouldn't go up because of the zoning. The road is residential and the adjoining property is commercial. I said, that's the problem. The county's using our residential road for commercial purposes. We were informed we don't have the choice. If this is the case, it should be eminent domain. The county should buy and maintain the road so it can be used as they want. This would benefit all property owners. I believe I proved the intent of the declaration. If you decide against us and let Duncan use our road, please make sure that the entire length of the road is paved and maintained by Bushnell per the recommendations.
Thank you.
Thank you.
So, is there anyone else who wishes to speak on this?
Carol Gant is also signed.
Is that the mom?
Yes.
Did you want to speak? Okay.
You could tell I don't walk the road. Good afternoon. My name is Carol Simbora Gant. I live at 18820 Sambora Drive, and I have lived there for 40 years, 40 straight years.
And you
If
were
the
sworn,
county
ma'am.
is telling me that I have no rights to use my privately owned driveway as I want, then the county should buy it. I would love for them to buy it. The county should make it a public road, since you are making me use it as a public road. No matter who paves and maintains the road, please make sure the entire Sambora Drive is paved. It sort of narrows down because they figured, Mom and Dad figured at the time we didn't need a big car. Anyway, please put into the paperwork that the road shall be paved and maintained by the recommendations of the planning board and by the county standards. I just say, this is very woodsy and we love the area, and we've been, like I said, in Pasco County for 40 years, and before that, in many years in Hernando County. I would love for the county to buy it because I'm in my 80s and I'm not going to be able to be paying taxes on that road for many more years. So please do us a favor and do the company a favor. Make it a nice road and ownership so I can walk down to Dunkin' Donuts, especially on Sundays. Thank you for listening to me, because I haven't done much in the nature of these talks since I was a cheerleader. And now I'm not a very good cheerleader. So thank you very much, and please help us in this case. Thank you.
Question for you. There's a preschool on that. Is there a preschool on Sambora?
Yes.
Okay.
Yeah, I can't hear very well.
All right. And then who owns the property next to the Suncoast? Looks like it's a junkyard.
That is actually Lebrano. He owns, I think it's almost 20 acres, who also owns the home that my parents lived in next to us.
Is that a junkyard?
No, there's no junkyard. No, there's some equipment there because he owned one of those companies that fill in sinkholes. So there's a sinkhole repair equipment there, but no, all that property is for sale. As a matter of fact, we're getting offers all the time for somebody, they want to come in and buy all our property.
I bet they do.
Yeah, they do, and I wish that everyone would agree, because, we could retire very nicely.
Yeah.
But yeah, and see, the road itself is 0.24 acres. I mean, it's a quarter of an acre, and when the regular house is on less than a fifth of an acre of land, we're talking about a good chunk of land here. And it would just be so much easier if the county, we did the eminent domain and the county just bought it.
Yeah, that's not something that we do, but I'm sure we have some questions for the applicant and the staff.
There's no one else signed up.
Okay. So can you say again what's going on with the road and who owns the road?
So why don't you finish your public hearing, and then
Well, he said there's no one else well, does anyone else here wish to speak on this? Anyone online?
No.
Yeah. he said
Thank
that
you.
already. Okay. Can you explain the road again, because maybe I missed something.
Yes, I can explain the road again. So Sambora Drive is an ingress-egress easement. It's about 20 foot in width, so that is what the declaration of easement is. That declaration does not limit to commercial properties or residential. It is a simple ingress-egress easement for the subject site. So that's what's going on. And I will state that the applicant or a successor owner shall maintain Sambora Drive to standards in the section 901.4 of the Land Development Code for all portions of Sambora Drive abutting the subject property. So that's what they're agreeing to into the deed restriction. So they're saying that it will be paved and up to county standards, but that is an ingress-egress easement. So they don't own that property underneath. They're just allowed to use the subject site owner, the property owner.
Okay, who owns the easement? Whose easement is it?
I believe it's their easement. Let me rephrase that. It's
Okay.
their property, but the applicant has an easement to use the property for ingress egress.
And will maintain it?
That will be within the deed restriction. So they have voluntarily agreed to a deed restriction that them or any successor owner shall maintain Sambora Drive to the standards in 901.4 of the Land Development Code.
Okay, and who owns, is February Lane a county-maintained road?
February Lane is a county maintained lane, maintained road.
This is whose district? I'm asking questions of your
It's all
district. And,
Chairman, if I
Yes.
may continue on. So Liam, the declaration of easement that you passed out.
Yes.
Somebody from your staff or survey has reviewed it.
Not from survey, staff has reviewed it.
Okay. The parcels that are listed on Exhibit B are the description of the applicant's property?
Yes, but I'm not an expert surveyor, so that's what
Well-
I'll say for the parcel.
So what I'm trying to find out is this easement to the applicant's property? So somebody should have looked at, if you're passing this out for the purposes that this easement grants the applicant the ability to use it, somebody on our staff should have checked it to make sure the legals coincide with this piece of property. That's all I'm asking. Has that review been done?
it says in here, accepting.
I do have a copy. Give me 1 second.
The second paragraph.
Yeah, the second paragraph describes the easement. 10 feet on each side of the parcel.
Accepting the east and accepting the west.
Verified that it does. The applicant's parcel is the one that's denoted as parcel 1.
Okay. And the legal that is the easement is Sambora Drive.
That's correct.
Okay. So parcel 1 has the legal right to traverse this road. It is not, I agree with Liam's statement. There is nothing here that would indicate that this easement was granted for purely residential purposes. When they were sold off, they were entitled to have the easement just like
Well, there's
the
a
original
business on
parcel.
there already. There's Pitter Patter preschools on that road. So, at least that's what it says here on Google.
Yeah.
Yeah,
Okay,
and
I
that
think our
business
hands are
is parcel 2.
Yeah, but it uses Sambora.
That's correct.
Yeah.
Yeah. Well, Jack,
Got a couple questions too.
okay?
Thank you, Madam Chair. Right now, Sambora, that runs north-south, correct? So if, in fact, we bring utilities alongside on County Line Road, do they have to connect? My anticipation that wouldn't be have to if they're on County Line Road.
Mike Carvalho. So typically, if a gravity sewer is provided, there is a forcible connection that has to take place under state law, but if there's force mains or water, then based on current policy, it's not obligatory.
All right, so, and if we're going to try to make this whole area grow with water and sewer, we're going to need to make a connection happen. So because you have a frontage road down below, you're separating it from County Line Road. Is this something we can do, and I guess this question for Denise, if not for you, that can we put a condition into if the sewer line's provided on County Line Road that they have to connect.
To the Euclidean zoning, so you can't condition it.
Can't condition it.
That's why he's tendered the covenants and restrictions.
Mhm.
But, would be, if there's sewer available, it would be odd that the health department would give a commercial.
Certainly, yes, certainly our experience with the health department is if it's there and available when the time came to renew or to do whatever, let's just say well and septic are involved and there is facilities available, there is still a process that they would go through. So, I mean, theoretically at that time, it could be forced. I mean, I would think.
All right, from what you can see, or if you can see from what's, well, I guess you don't see the map now, but with that line in there, would it be a normal thing to have a connection like that stubbed out to Simbora Drive to make the connection?
If a line were to be put in to have a stub out or a connection point, certainly, that's not anything difficult.
All right, so if we did have the line going across, all we'd have to do is just draw a stub out line and then they'd have to connect.
That could be designed into the process, of course.
Okay. Do we find out do they have sewer or not?
So my records from the team show that it's kind of in that area, what we discussed this morning, where there really are no Pasco County utilities located right there.
Oh, there are none.
No.
So can I ask the applicant back up?
Yeah. Todd?
So, Mr. Pressman, do you think that the owners would agree to hook up if we did bring utilities in place for sewer?
I'm sure they would.
Okay. Let's
Well-
step any further?
Don't, be careful what you ask for, because you don't know the cost yet, so, I mean, it would be part of a team of people bringing it up, right? That's what we were talking about this morning. Since there's no utilities there, it's a hindrance to development.
As I looked at my notes, the last discussion I had with the applicant was they had talked with Hernando County.
Yeah.
But then I understand that is somewhat, as I'm learning this afternoon, that is, or from this morning, that's a little in flux from what I'm being told.
Right, so the way I look at it is if we're going to be, and just thinking this as we've gone through the day now, looking at this whole thing, is I think our best move as a county is to actually look at all the businesses up and down the line that say they'd connect, or they'd like to connect, or they even contribute to doing so, that it may make the whole thing feasible all the way through. But it's going to be a little bit of a process. But yeah, with that interlocal gone now, they're not going to let you hook up or you'd be cut out after 2 years anyway.
Say again, please.
In 2 years' time, the Hernando agreement is going to go away. So they're not going to, I don't think, let you hook up anyway at this point. So for you, for long-term, if we looked at it, it'd be good if we could reach out and make contact to say, look, we'd like to hook up when you can make it available. Okay. Thank you.
Okay, so with that, take a motion.
Move approval.
Second.
All in favor? Aye. Okay, then we are at
P89, we have proof of publication in the April 20th, 2022 edition of the Tampa Bay Times.
Item P89, sorry, Liam Devine, Planning Development. Item P89, PDD 22-7617, in the name of Eric Dominic. It is zoning amendment from AR Agriculture Residential District and R1 MH Single Family / Mobile Home District to a RMH Mobile Home District. The subject site is located on the southwest corner of the intersection of Tucker Road and Michelle Lane. And here is a look at the aerial view. The surrounding future land use to the north, south, east, and west is Res 9. The surrounding zoning to the north is AR, RMH, and R1. To the east is AR, RMH, R1MH. To the south is AR, and to the west is AR. The subject site is currently undeveloped on approximately 15.22 acres. The applicant proposes to develop the property with a mobile home subdivision in conformance with the RMH Mobile Home District standards. Access to the property is from Tucker Road, a county-maintained local road with approximately 40 feet of right-of-way, and abuts Michelle Lane, a privately maintained local road with approximately 30 feet of right-of-way. The surrounding area is characterized by residential development, mobile home subdivisions, and travel trailer / recreational vehicle parks. And the future land use is Res 9 under the comprehensive plan. This is coming with a recommendation for approval from Planning Commission and Planning and Development Department. I'm here if you have any questions.
Could you put the map back up again?
Oh, of course. Do you want the aerial or you want
Just the
zoning?
aerial.
Okay.
And, okay. All right, board members, any questions? Is there anyone here from the public that wishes to speak to this? Okay, well, we don't have to have a presentation. We
Move
can.
approval.
Second?
All in favor? Aye. Opposed? I should have said, is there anyone online? But you didn't speak up.
There are
so-
none.
Okay. All right, so that is done. I believe that we are done for the day. Is that it? Okay. We are adjourned.
And we have items for you to
All right, I'll go sign.